Hey everybody, it's Tracy, and I wanted to talk about state no action letters. And if you follow securities industry at all, no action letters are fairly regular in the sense that issuers of securities are always asking for them. And what they are is basically an inquiry that you make to a financial regulator, and you ask them a question. And they don't answer the question, but what they just basically say is, if you go about doing what you've described in this letter, we will not seek to file an enforcement action against you for doing it, right? They won't say it's legal, they'll just say, we're not going to go after you for doing it, right? And the thing is that financial regulators at state or federal level don't even have to offer a response, but in most cases, if it's a somewhat common issue or model or significant enough, they will. And the value of that is armed with this no action letter that says, if we propose to operate in a certain manner, in a certain operational strategy, then at least we have some asterisks, that guidance that we will not subsequently be pursued for violation of any law, whether civil or criminal. And while it's very common in the securities industry, it's also becoming more common at the state level in the context of money transmission laws and money transfer licenses. And the reason is because you have, with the exception of 2-3 states, you have archaic money transmission laws being applied to not only crypto, but even Fintech operations, right? Even like as something as common as neobanking, right? So you see more and more people and promoters and companies seeking these no action letters. And there is value to it, because when you get down to like a granular level, especially with various like aspects of like decentralized finance, banking as a service, some software as a service type thing, crypto as a service, things like that, you find that there really isn't any existing law on the topic, and there's nothing that you can really base your decision on other than reading what's in the Money Transmitter Act for that state, or states as it may be, and it's not going to help you a great deal, right? Because it just doesn't apply, because it's like a wildly new thing. So you go about requesting this, and the limitations of the letter are that, one, it only applies to the very, very narrow description that you put in that letter, right, in that question. Two, as I mentioned before, it only details and states not what you're doing is affirmatively legal or within the bounds of the law. It just says that that regulator is not inclined to pursue you for some kind of civil enforcement action should you continue to operate or start to operate. And three, while it's binding to a point, it's not forever binding. So at any time, right, a financial regulator can simply come in and say, well, we no longer, want to give you the protection of this no action letter, or alternatively, we now view your options to have gone outside the description provided in the request, in the no action request, and thus we can pursue enforcement action. And like one of the more common things, especially with the election just happening, is the difference between Kalshi and Polymarket. Well, Polymarket, has had operated under this no action letter from state gaming authorities and state securities boards, but those were starting to be not so much rescinded. They just got noticed that, hey, listen, we don't care what we said before. So what you did before was fine, but now we have a problem with it. And as a result, they stopped onboarding U.S. persons, even though I could go on my computer right now and onboard if I were inclined to do it, right? So that's the nuance between these no action letters. They're good to a fault, but in the absence of spending a whole lot of money on a license that you may not need, or spending a whole lot of money on a license which will subsequently become moot because there's either federal level, especially like in the crypto context, regulation, or state by state crypto type regulation, it's kind of worth the shot, right? Because the letter doesn't really take much to do. You just have to wait for the reply. And in most cases, what you're attempting to accomplish is well beyond the scope of any existing laws. So it's for very unique platforms. And I kind of draw the comparison to like the offshore environment where you have the sandbox, right? Like BVI has a sandbox, Bermuda has a sandbox. All these places have sandboxes, right? Which are, you can operate on this very limited level and scope to sort of see if you can get a foothold and allow regulators time to kind of understand how they would regulate you should you go on to obtain a full license. And this is sort of our equivalent because we don't really have it in the US, right? So send the letter, hopefully you get a response. They say, we're not going to do anything for now, and you can go try it out, right? And if down the road the writing becomes, apparent in the law that you need to go get a license of some kind, or the laws change, then you go ahead and do it. But that is the sort of concept and mechanics behind the state financial regulator no action letters, and for the relatively minimal effort that goes into it, if you have something that you're unclear of, right, and you don't want to invest in like the money transmission licenses, and note that you need to get a no action letter in every state in which you operate, it is really a great route to sort of avoid that cost, but it's perhaps not a permanent solution, right? And that's the key thing to remember when you're going through it. And of course, you may need 50 of them depending on what you're attempting to do and where you're attempting to operate. So, if you have any questions regarding state financial regulator no action letters, definitely hit me up, adamtracy.io. Talk to you next time. Cheers.